Judge is ordering ChatGPT owner OpenAI to now give lawyers 20 million private chats. Those 20 million people weren't asked and were not notified.
That judge is now dismissing all privacy concerns brought up by OpenAI as they look to make their anonymization process to solve the problem.
Queen City News Chief Legal Analyst Kelly Frodes joining us this morning. Okay, we know this is a civil suit going on. Where are the boundaries when it comes to what can they do when it comes to the privacy of citizens?
Well, I like folks to first make sure they're following and tracking at home. OpenAI sent this out the other day in some type of presser from their information officer, basically like appealing to our heartstrings as users to shift the victim stance from them as defendants in this case, which is litigation, to now as defendants of us as users. And I think it was well crafted. The only thing that was missing in their press release was that this has already been decided. A judge has already talked about this. Now, why OpenAI is a $500 billion company looking to have an open IPO for a $1 trillion, that's with the T, they're going to be spending a lot of that money in litigation. And one of those litigates is the New York Times. The New York Times is still suing them because they believe they've infringed on their copyright material. So you talked about 20 million users. They want to be able to see that information, and it is anonymous. And so the judge actually wrote that. They said, well, OpenAI has failed to explain how its customers, us, privacy rights are not adequately protected. The existing privacy and protective order in this litigation is there, and they have identified, or I should say de-identified, all of the 20 million users. They go on to say that OpenAI, they have listed a number of ways that these folks can even look at this information. If you're viewing it, you can't be on a computer that's connected to the internet. You have to be in a room. You can't bring any additional information in there. So the court has placed a number of protections already there. OpenAI just doesn't want to turn over this information. And normally when you don't want to turn over information, you can do two things. You can appeal to the court, you can appeal to the public. They're attempting to appeal to the public, and they've request the judge to reconsider her order. I don't believe the magistrate judge, U.S. court judge, is going to do that in this situation. And so now they can just lay it on us and make us say, hey, why is my information being sent out there? But I think that's a misuse of the terms, and the court clearly said that. This is not them saying, here's Annie's paperwork. They won't know because it's anonymous.
Right. So do you think we're going to see more cases like this? Because as you've brought up many, many times, lawmakers are kind of behind the 8 ball, right? When it comes to social media, there were things that were kind of being drafted as it happens. But now with AI, do you think we're going to see more cases like this where we're kind of figuring it out as we go?
I mean,
or is there a lot of precedent for
They're
it?
already seeing it. I mean, that's why I mentioned that $1 trillion evaluation. Yeah, they'll get millions and millions and billions of dollars when that eventually goes public. But a lot of that will be used in litigation. And so most of the folks that are in Congress right now think of OpenAI or any type of AI as Google, plus. They're not recognizing that it has way deeper ramifications. And the largest part of it is that large learning module that most of these things use, acquiring and grabbing information from multiple places to help its information learn. Because it works like that, the problem is they're not recognizing the infrastructure. And that is to OpenAI's point. That's what they said the judge didn't understand. They're like, the judge doesn't even understand what they're allowing them to see. And I do agree with that part, but the judge has already spoken. And so now to put this out there as if you're defending the public, and they even went on to say that for years, the bedrock of the institution of media has been to protect the rights. And then they're saying, but now the New York is going the opposite way. They're just asking to find a way to prove their case. The only way you can prove your case is through the discovery process. I'm asking you for information from you that I need so that I can help prove my case. You have an obligation on the other side to turn that information over. Right now, we're in the discovery phase. They don't want to turn it over. Because when you pull back the curtain, you get to see how the sausage is made. And if you see how the sausage is made, you can say, hey, I'm recognizing that you have hundreds of millions of times you've used my data to support your information. Typically, that means you've paid me for that, and I haven't been. That's why we have a lawsuit.
Typically, when we're speaking, typing, having a conversation with AI, we assume that there's secrecy and privacy, right? A lot of people are exploring adult conversations and other things, right? There's a lot out there, right? If you go back, almost 25 years now, post 9/11, you look at the Patriot Act, where you had President Bush tapping phones. All that was because there was, terrorism happening, and it was to avoid that. How do you compare that to what's going on now when it comes to privacy? You got legal discovery, and then trying to prevent terrorism domestically. But privacy is still the issue in between.
I think if the government is coming in and saying there's a national security concern or issue, that there are operate things that they can do to actually get access to that information. But this is a private company attempting to sue another private company. And in the process of doing that, normally the discovery process means there is a litigation hold. The day you find out that there's a lawsuit, an email will go out in both companies and say, hey, freeze everything. Don't delete anything. Don't remove anything. Because we're being sued, we have an obligation to save and preserve all our documentation. Yeah. Why? Because from the day I filed a lawsuit, I want emails going from this day all the way back. So if you start deleting, I'm saying, well, I'm gonna get a record of that. Mm-hmm. Why did you delete that? I wanna know what those emails are. So that's why that happens. That portion is there to protect both the company and the litigants from ensuring that nothing is destroyed during this discovery process. But that national security issue, I think if it was a government, I think this would go a different way. But even Apple fought back to that. Mm-hmm. They stood their ground and said, we're not gonna open up our phones and our users' phones just because you wanna say that it's national security. If you wanna go open them, figure out a way to do it yourself. I think if you're an end user, a person that's logging on, you should recognize that your private name, at least connected to your search, will be protected. Will your private search be protected? Not apparent to this judge. She's saying if you're one of those 20 million users, yeah, your information will be out there, which I think they have a right to see if you're using their proprietary information.
All right. This is an interesting one, so we'll keep track of it. Khalif, thank you so much.
Queen City News Plus. Just search Queen City News on your smart TV's app store.